This Honorable Court of Appeals is now in session. Please be seated.
Good afternoon, and on behalf of the Tennessee Court of Appeals, welcome. Thank you, lawyers and any parties for being here today. Your panel consists of Judge Arlen Golden from Memphis, Judge Carmen McKee from Savannah, and my name is Skip Frierson, and I'm from Morristown. Each side will have 15 minutes for oral argument. Appellants, counsel can, or any pro se litigants can reserve up to 5 minutes for rebuttal. And please be mindful that these oral arguments are being live streamed. Madam Clerk, are there any preliminary matters?
No, Your Honor.
Madam Clerk, would you please call the first case?
John Doe et al. Versus Bellevue Baptist Church.
Counsel, you may be heard.
Gary Smith of the Memphis Bar. I would like to reserve 2 minutes for rebuttal.
Thank you.
How many? How much? I'm sorry, what did you say?
2 minutes. This case involves a sexual assault, a serial, over a period of time, sexual assault of a minor girl by an employee of Bellevue Baptist Church. Bellevue argued in the trial court that unless the parents who also sued actually witnessed the sexual assault, there is no actionable claim for negligent infliction of emotional distress for the parents. The trial court agreed, entered a dismissal as the parents' claim on the front end, but allowed the minor child's case to go forward. We were later able to take discovery on the child's case, which provided pertinent information even as to the parents' claim. After and at the time of the settlement of the child's claim, we came back with a motion under Rule 54 and Rule 60 for reconsideration because there was no final judgment on the parents' claim. The church asked for one. The trial court had denied it. So that case was still open. We also filed a motion to amend in view of the discovery information that was revealing in the case. The trial judge denied both of those motions, sticking by the original ruling, and it is from that we appeal. So the church's position was, unless parents witness the assault, they have no actionable claim. And my question is, in what world would that be true? It should not be true in this one, and it's not. If one, on behalf of the church, could have argued that the law formally supported that position, you know, that wouldn't be totally wrong, but it changed. And I want to address that change, but first, the position that they take today is different from the admissions made by their own witnesses in discovery. Associate Pastor Heineman spoke to the father the day that this was discovered by the police and said, yes, he was grieving and there was nothing I could do to help him. The lead pastor, Stephen Gaines, and Associate Pastor Hammond both admitted that when your child is sexually assaulted, that is devastating to the family. So the practical effect of what they have acknowledged is far different than the position they're taking legally here. Now, even though the trial judge did not dismiss the case for insufficiency of negligence having been pled, I think for context it's important to name just a few, and there are many reasons why there was negligence. When the plaintiff family joined Bellevue, there had been a prior history between the perpetrator and the mom of this child. There had been an affair years before. The family revealed that to the church upon their admission and knew that this ultimate perpetrator was in a position in the children's department of the church and warned them This man is not who you think he is, and keep him away from our kids. The church ignored the warning and did not honor the request to keep him away. Over a period of time, this employee groomed the child in the presence of other employees. Now, he even would take her out of the classroom where she was volunteering that he arranged on Wednesday nights when he was not working and was not supposed to be in that department. And he would take her out of the class where she was helping, take her to other parts of the campus where some of the events of sexual assault occurred, and then he would return her to the classroom. Nobody stopped it. Now, it's true that over time they would meet outside the church premises, but the grooming occurred at church and nothing was done to stop it. Ultimately, when Kaluzny, the director of child services, became suspicious because he was hanging around on these Wednesday nights when he was not supposed to be there and was hanging around this child, she goes and reports it to the associate pastor, Ken Heineman. Pastor Heineman already had knowledge of that past history, and he calls in Mr. Hook, the perpetrator, and confronts him about what he's doing with this little girl. And he testified that because he did not get satisfactory answers from Mr. Hook, he fired him. Now, the suspicion is something inappropriate is going on here. They had been warned to keep him away and that he was not who they thought he was. And even then, in spite of the fact that they fired him, they did nothing to warn the parents or tell them so that they could intervene, and these sexual assaults continued to happen until he was finally caught in a public park with her in the wee hours of the morning in a not appropriate state, and he was arrested. So not only did they not heed the warnings, even when they had the suspicion enough to fire him, they did not still tell the parents so that the parents could intervene and get this stopped. Director Kaluzny even testified that if she had seen him taking this child out, she wouldn't have stopped it. And that is directly contrary to their policy, which says 2 adults with a child at all times, all caps, no exceptions. And she acknowledged that she would have violated that policy. But as and the church was well aware, and the testimony reflects this, that they were very attuned to the risk of sexual assault in the church setting, knowing, and this is actual testimony from the church representatives, knowing that the church is ripe for people who would take advantage of the authority position and the trust that is engendered by that authority position in a religious setting and commit sexual assaults. That was the reason they had their policy. So, as indicated earlier, the court initially granted the motion to dismiss as the parents denied our motion under Rule 54 and Rule 60 at the end of the case, and denied our motion to amend, which was simply to add some features that were a product of the discovery. I only have one thing to say about the motion to amend. Bellevue has said in its brief that after the minor's case was settled, there was no complaint to amend. That's not accurate. It was not a final order as to the parents, and in fact, the order dismissing the minor's claim and the order of ultimate dismissal as a final order of the parents' claims, all the same order. So the case was still pending. It was subject to amendment. Now, I want to make 3 references to case law that are pertinent. Camper versus Minor. Supreme Court held that to avoid arbitrary rules that eliminate otherwise meritorious NIED claims, knowing that the history of restrictions that had been in place were a function of making sure that NIED claims without merit did not proliferate. But Camper versus Minor recognized the need to avoid those arbitrary rules. Henderson versus Vanderbilt. This court's case, I was plaintiff's counsel on that case, recognized, and the author was Judge Stafford, quote, both the need to be present for the injury-causing event and the need to be closely related to the victim have been eased in certain situations. Well, we have the closeness to the victim here, it's the parents, but the need to be present for the injury-causing event has been eased in certain situations. Is exactly what we're talking about here, because the trial court held that you need to be present for the injury-causing event. What parent is going to witness their child being sexually assaulted and not stop it? That does not fit. The Henderson versus Vanderbilt opinion, I promise you, is the seminal treatise on the history of and the evolution of NIAID claims in this state, period. The court went on in the Henderson opinion to recognize that the trend is to relax restrictions on meritorious bystander NIAID claims. Doe versus Diocese has, Supreme Court case, has 4 things that are important, but the one that I think absolutely fits here is they said the gap in tort law, if conduct is directed only at an individual, cannot stand. Meaning, in a case like this, the parents who are not the actual physical victim, if they cannot recover, if they do not have a cause of action, there's a gap in the tort law that has to be remedied. Now, in my remaining 2 minutes and 50 seconds, I want to talk about.
Do you have any, is there any Tennessee case that you can cite to us that has these facts, that would extend it under these facts to a third party?
I did not catch the last part of that, Judge Golden.
Extend it to a third party, like in this case that you're asking.
Yeah, the Doe versus Diocese does. It specifically was a mother bringing a suit for the abuse of her child by a priest. So yes, Doe versus Diocese.
And that's, what's the site on that?
I do not have the Lexus site, but it's a 2005 Tennessee Supreme Court case. I have it behind me. I can get it. I'll give it to you on my rebuttal.
What is it, Doe v. what?
Doe versus Diocese of Nashville. And it is cited in our brief extensively. There's a few points I would like to make with reference to their brief. They start off in their brief saying, and this is a quote, Tennessee still follows the zone of danger approach to NIAID claims. That is false. And they seem to cite Ramsey versus Beavers for that proposition, but here's what Ramsey versus Beavers says, quote, our holding today abandons the hyper-technical approach of the zone of danger rule. So their whole concept of this zone of danger and the parents has to be present is just flat wrong. They didn't read the whole opinion. Then they make 3 policy arguments. One, they say you shouldn't allow parents to make a claim like this because it could raise insurance premiums. Well, if they're more worried about insurance premiums than they are sexual assault of children, the priority is wrong. They say that it would open the floodgates to the courts for these types of claims. That would be true only if there was a flood of sexual assault of children in churches. And if there is such a flood, we should open the floodgates. And then finally, I really had to digest this one. They say there is a moral hazard in monetizing claims for sexual abuse in favor of parents, as it would lead to perverse incentives. The list of pejoratives I could use to describe that aberrant concept is endless. I won't. But to say that if the court allows parents to make such a claim, it would incentivize parents to allow their children to be sexually assaulted is ludicrous. All 3 of their policy arguments fail. For all of those reasons, we would ask the court to reverse the motion to dismiss and the denial under Rule 54 and the motion to amend and remand for trial.
Thank you, counsel. You have your time for rebuttal. Yes, you may be heard.
Please, the court. Initially, I'd like to acknowledge that the use of the phrase zone of danger approach was a inartful and regrettable We know that that's not the law in this state. And to be clear,
Can you identify yourself?
I'm sorry, Your Honor. William Johnson on behalf of Bellevue Baptist Church. My apologies. To be clear, in the underlying case, we never even used that term. None of our motion papers, none of our reply papers, none of the opposition to plaintiff's motion, nor oral argument was that issue ever raised. So that was a regrettable, lack of a better term, brain freeze. But the issue here is that the trial court was appropriate to grant our motion to dismiss. It was, first and foremost, plaintiff's complaint failed to set forth facts which would substantiate a claim for bystander and IED. The complaint is devoid, in fact, of substantive facts. As our Supreme Court held in Eskin, there are 4 pertinent elements to a bystander claim for an IED. Actual or apparent death or serious physical injury of another caused by a defendant's negligence, existence of a close and intimate personal relationship between the plaintiff and the deceased and injured party. Number 3, plaintiff's observation of the actual or apparent death or serious physical injury at the scene of the accident before the scene has been materially altered. And 4, of course, the resulting serious or severe emotional injury to the plaintiff. Here, the pertinent issue is this third element. That is, the plaintiffs neither observed any sexual misconduct, they were not in the physical proximity of the alleged misconduct, and they only learned of the abuse after the fact. So the trial court appropriately applied Tennessee law. While the plaintiffs in their briefing failed to explicitly acknowledge this indisputable truth, and only did so begrudgingly here, what they're actually asking the court to do is to rewrite the law on emotional distress by abrogating or removing an element of the claim. In a review of Tennessee case law, plainly, as counsel alluded to, the law has evolved over the years. We have seen that it is, the elements have, the manner in which the court has interpreted the elements has evolved to allow more claims. But it has been done in a logical and methodical manner. But one thing that has always remained unchanged is the requirement of witnessing the incident or the immediate graphic aftermath. That's a necessary and critical element here. And that's because knowledge that something bad happened to someone is not the same as observing the incident or the immediate aftermath. As our Supreme Court noted in Ramsey, obviously it is more foreseeable that one witnessing or having a sensory observation of the event will suffer effects from it. Here, the only information that the plaintiff's parents had was what they heard after the fact. That does not constitute a compensable claim in Tennessee. I'm not aware, in fact, of a single Tennessee case that is elected to disregard that element of the claim, including the Henderson case that counsel cited. Those parents were present the entire time that they watched their child decline, and they got to observe multiple acts and omissions by the Vanderbilt medical staff, which resulted in the court holding that they had a valid NIED claim. And if the elements of this claim are to be abrogated, I would respectfully submit that the Supreme Court needs to do that, since we were talking about Supreme Court precedent here today, namely removing an element of the claim. And there are no grounds to disturb this court's ruling, the Supreme Court's ruling, or the trial court's ruling. The question here is whether this is a compensable mental injury, to which the answer is no. The Supreme Court has defined what a legally compensable injury is, and the commonality in all cases is witnessing the injury, producing event, or the immediate aftermath. Now, relative to the second issue that is before the court, the plaintiff's motion for reconsideration of the trial court's order dismissing the NIED claim and their motion to amend. The motion for reconsideration was not based on any new facts, law, or evidence. It was ultimately predicated, it was a rehash of everything that had been raised in the opposition to the motion to dismiss. And it is notable, too, that although the motion to dismiss had been granted in November 2010, November 10th of 2021, it was not till 7 months later that we're back in court on this motion for reconsideration. There were no new unique, exceptional, or extraordinary circumstances which warranted reconsidering the motion. With respect to the motion to amend, the timeline is also pertinent because, again, the lawsuit was filed in April of 2020, and here we are, June of 2022 is when the motion to amend is filed. The facts is that the defendants knew of the perpetrator's predilections because that was alleged in the underlying complaint. They say we knew or should have known of all these issues and that we disregarded and ignored our own policies and procedures and violated our duties. And, you know, listening to counsel's arguments regarding the facts, we're not here on the minor victims' claims. We are here on the parents' claims. The minor victims' claims have been resolved. What else? The undue prejudice to the opposing party, based on the timeline of events, there's obviously undue prejudice, and there was futility of amendment. All those warranted the court granting or denying the motion. I have nothing further, Your Honor. Does the court have any questions?
Thank you, counsel.
Thank you.
May I have his 8.5 minutes? Judge Golden, the site on that case, Doe versus Roman Diocese, is 154 Southwest 3rd and the site we're using is at page 39.
Thank you.
Just a couple of comments. He again argues that the parents didn't observe it. Well, of course they didn't, or they would have stopped it. But in Doe versus Diocese, that mom did not observe it either. She learned about it later. And the Supreme Court says that that case was actionable. There's one other difference in this case than the typical bystander claim that I think is worthy of consideration, and that is the direct nexus of the negligence claim, not only from the church to the child, but from the church to the parents, because in this case, two things were true, as alleged. One, they warned the church about this guy not being the person that they think he is and were instructed, do not let him near our children. That is a direct nexus to the parents for a negligence claim. And as I said, the warning was not heeded, nor the prohibition on letting him be around their children honored. And then there's another feature. Remember, the child was working as a volunteer in the Child Service Center. The parents gave that child to the church with the expectation and trust that she would be safe. And for both those reasons, I think the parents have a direct negligence claims themselves. Time is up. Thank you.
Thank you, counsel. We thank counsel for your briefs, oral arguments, and the opinion of this court will be issued in due course. At this time, we're going to take about a 5-minute recess. Madam Clerk will resume in just a few moments.
All rise.